So Gun Owners of America just filed a lawsuit against the ATF because of the ATF's new rule on frames and receivers, which will go into effect in August. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also want to mention that if you're interested, we do have channel merch available. I will leave a link down in the details section. There are 3 different t-shirt designs. One of the shirts comes in 2 different colors. So if you want to support the channel, that's a great way to do that, is buying channel merch. And again, I'll leave a link to that down in the details section. So I guess in the intro, Gun Owners of America just filed a lawsuit against the ATF because of the new rule on frames and receivers, which the ATF released just a few months ago. We all know a lawsuit was coming, and GOA is going to be the first one who's striking back at the ATF and their new rule on frames and receivers. This lawsuit also is coming on the heels of the recent Supreme Court ruling in Bruin and also the Supreme Court ruling in West Virginia v. EPA, a case which established the major question doctrine as a consideration when looking at an agency's actions instead of Chevron deference, which has been granted to agencies like the ATF. This lawsuit by GOA against the ATF and their new rule on frames and receivers may be the first Second Amendment case we see proceed forward start to finish under those 2 new Supreme Court precedents. And because of that, this is a really big deal. Now, if you're not aware of what this lawsuit entails, this lawsuit is against the ATF because of their new rule on frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80% kits. Under this new rule, 80% kits are treated as actual firearms and are defined as actual firearms. This new rule went into the regulatory definition of a firearm and changed that definition through a web of references to include 80% into that actual definition. Since 80% kits are now considered to be actually firearms, they are going to be subjected to serialization requirements and also background checks as well. Under the new rule, the primary impact will be on gun stores and gun manufacturers of these items. An FFL or gun store will now have to serialize 80%ers that they have in their inventory when this rule goes into effect. So gun stores will have the burden of serializing their inventory and any future items, any privately manufactured firearms that come to them from other sellers. On top of this serialization requirement, they have the responsibility of running background checks on individuals who purchase these items from a gun store. So going forward, after that effective date in August, you will only be able to purchase an 80% kit from a gun store if the item has a serial number on it, and also only if you have a background check run on you. Now, one of the larger impacts that this new rule will have is on manufacturers who sell these items. The manufacturers will be required to serialize all of their kits that they currently have, and they will also be required to serialize any future items that they manufacture. There is also the requirement that since these kits are deemed to be defined as firearms, any manufacturer of these kits will now need to be an FFL holder. Now, the last important thing that this final rule did is it changed the retention of records requirement. The new rule states that FFLs must now maintain firearms records indefinitely instead of just for the 20-year period that's currently law. This has brought a ton of concern because eventually the ATF can get their hands on almost every firearms transaction. When a business closes down, they will have to send all these records that they had to maintain forever to the ATF, and eventually the ATF will retain and get all that information, and through that process, they will essentially have a backdoor firearms registry. So that is a general gist of the final rule on frames and receivers and what it did, and that is what's being challenged here in this GOA case. Now, this case was filed in North Dakota in a district court, and the complaint is about 150 plus pages. So I've gone through most of it. I've read most of it. It's pretty long. It's pretty comprehensive. And I just want to break down and point out a few really important things that popped out to me when I was reading this complaint, and want to give you kind of the main takeaways from that complaint so you know what this lawsuit is about without having to read the whole 150 pages by yourself. So the first section of the complaint I want to talk about is the cause of action against the ATF based on separation of powers. GOA states that the final rule is invalid because the final rule represents an attempt by an administrative agency, the ATF, to implement policy change through regulatory process, through bureaucratic regulation, instead of through actual legislation. In this section, they hit on the important distinction that a regulatory agency is not supposed to create legislation. Instead, that is the job of Congress. Now, this section, I think, will be eventually amended and added to based on a recent Supreme Court ruling in West Virginia v. EPA. In that case, the Supreme Court issued a 6-3 opinion authored by Chief Justice Roberts. Now, although the West Virginia case dealt with the EPA as an agency, the case and ruling has a much broader impact. Really, that case was about what authority do executive agencies have. In reaching their decision, the Supreme Court said the case involved the major question doctrine. Under the major question doctrine, when an agency's interpretation of an ambiguous statute concerns an issue of vast economic and political significance, the court must deny the agency the deference traditionally afforded to it under Chevron. So the West Virginia case was important because it drastically limited the ability of an agency like the ATF to be granted deference to enact rules however they wanted. Instead, under the major question doctrine, the only way that the ATF could do something like this in the final rule is if Congress expressly gave them the ability to do this. And here, Congress hasn't. So I would predict that this section of the complaint will eventually be amended and added to, or this issue will come up during briefing. The Supreme Court just recently ruled on that West Virginia case, so I don't know if they didn't have time to add it into this brief. I didn't see it mentioned anywhere. I might have missed it, but I would expect that that will pop up at some point. The next major aspect of the complaint I want to point out is the discussion about the recent Supreme Court ruling in Bruin. In this section of the complaint, GOA points out that the entire basis in which the new rule on frames and receivers was created upon is an interest balancing approach which the Supreme Court just expressly struck down. The complaint states the final rule specifically and expressly justifies ATF's regulatory promulgations on the basis that they do not violate the Second Amendment, on the theory that there are compelling governmental interests in regulating privately made firearms, relying on the two-step test concocted by federal courts of appeals applying intermediate or strict scrutiny. However, the Supreme Court's decision in Bruin declined to adopt that two-step approach used in lower courts and declined to engage in means and scrutiny generally, and specifically ruled out intermediate scrutiny as a test. In other words, the legal precedents on which the final rule relies have been soundly repudiated by the Supreme Court. The legal tests on which the final rule relies have been resoundingly rejected by the court. So essentially the argument by GOA here is that the Supreme Court already rejected the entire basis that this rule was built on. The ATF must try again, and in doing so, they will need to validate their new rule using text as informed by history, which, as we all know, will be very hard for them to meet and likely is not in their favor. Another important argument made in the complaint is that the ATF as an agency is prohibited under federal law from creating a national registry. GOA points out that the final rule's requirement that dealers maintain records indefinitely and then transfer them to the ATF when they go out of business is a direct violation of that federal law. The ATF's out of business record requirement represents an attempt by the ATF to establish a system of registration of firearms, firearms owners, and also of firearms transactions. And on that basis alone, the final rule should be struck down. The final argument I want to point out in the complaint is the argument that the final rule also violates the First Amendment's freedom of speech requirement. GOA points out that in this final rule, there is a determination that an object might become an actual firearm that otherwise has never been considered to be a firearm, that it could become a firearm if it's accompanied with some sort of speech. And the whole goal of this aspect of the final rule is to actually chill the freedom of speech. GOA states that the mere fact that speech accompanies an object cannot change the nature of an object. Communicating with someone about how to use an item does not turn it into a different item. Yet that is what the final rule indicates and what ATF recently has concluded. So I definitely want to give big props to GOA for this lawsuit, and I look forward to seeing them beat down the ATF in this lawsuit. Again, if you want to support a good organization, I do recommend you guys donate to GOA. GOA is a great organization. They do great things. And if you're interested, donate to them. Or if you want to donate to them through proxy, like I mentioned, you can also go to Blackout Coffee and you can pick up some coffee, and all those proceeds also go to GOA and help support them as well so they can file lawsuits like this, because lawsuits like this are not cheap. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorit's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.